Like to begin formally. So, my
Right.
name is Anshu. I am a senior editor at the magazine, and I'm also
Okay.
joined by my fellow senior editors, Arpit and Samvardhan.
Yeah. Okay.
So, we'd like to begin with who we are and what we do. So, we are a student run non partisan magazine started back in 2020 by Caucus, the Discussion and Deliberation Forum of Hindu College. So, Caucus basically functions as the 16-year-old mini think tank of the college, and we opine on like various issues ranging from politics, law, discussions on various other topics as well. So, for our readers today, we are joined by an eminent personality, senior advocate of the Supreme Court of India, Mr. Shyam Divan, who is famous for his contributions to numerous landmark cases under the Supreme Court of India and his work towards public interest as well. So, sir, on behalf of the entire probe, we would like to show our gratitude for joining here with us today.
My pleasure.
And I think we can begin formally with the questions then.
Yeah. Sure.
So, sure. So you have been at the forefront of the legal domain for a considerable period of time, participating in numerous landmark cases. To begin with, I'd like to ask you on your insights on how the Supreme Court has evolved since you began practicing. Additionally, what major challenges do you believe the court has successfully addressed, and which challenges remain unresolved?
So I commenced practice before the Bombay High Court, and I really shifted to practice my base to New Delhi to practice before the Supreme Court in 2006. So as a High Court practitioner, your perception of the Supreme Court is quite different from when you're actually there and doing the litigation before the Supreme Court. When I was in before the High Court, I made an occasional, of course, visit to the Supreme Court to when I was briefed in cases or engaged in cases as a junior counsel. But that's a little different. The perception in the High Court when you're practicing is that, all right, if there is a new principle or some direction which the Supreme Court is giving, then you try and take note of it through its judgments, and then you apply it to the facts of the case because high courts rightly decide cases on facts, as do all courts generally. The Supreme Court, as you know, is more to do with is sort of more concerned with questions of law, and the facts sort of in that sense are left to be determined by courts below. So, looking back, when you say evolved since 2006, I would say there are two or three things which strike me most, and I'll try and sort of enumerate them. The first thing which strikes me is that there's a whole bunch of new statutes where appeal now lies to the Supreme Court directly. So, what we've done, or what society has done through parliamentary legislation, is that we've created this bunch of specialist tribunals. The tribunals tend to bypass our high courts, and we have appeals which are directly before the Supreme Court of India. So that's one big change which I have seen, where the Supreme Court is suddenly at the apex, of course, of our general system. But then you've got all these technical appeals, from, for example, of course, the company law appeals which come through the National Company Law Appellate Tribunal. You have the National Green Tribunal, which is sort of something which got established after I moved my practice to the Supreme Court. You have a bunch of other specialist tribunals also, which have come up, for example, in the field of energy. So those are technical ones which come up. And then there are the more traditional ones, such as taxation. There used to be an appeal from the Securities Appellate Tribunal at one point of time to the High Court, and that has now moved to the Supreme Court of India. So I feel that there is one thing which has clearly happened is that the Supreme Court has been really burdened with all these specialist appeals which come directly from tribunals. And so this is a whole new area of business which the court has to do, supposedly in the area of just determining questions of law. So that's one area. So it's not just the general appellate and constitutional work coming through the high courts, but they've suddenly I think the Supreme Court finds that there hasn't been even one level of review as such by a high court before the case lands up before it. A second feature for me was the expansion of the Supreme Court itself in terms of its numerical strength. So when I came across the strength, the total strength was 26. And so at any point, you had probably 22 judges, etc. Now, as you know, there has been a sort of bounce up and the strength is now 34. So that's a lot more judges. And I mean, it's almost like a medium-sized high court, the Supreme Court of India, in terms of its strength. And that has its own impacts and effects because you have so many benches which are sitting now in terms of many more than you would if you had a strength of 26. So that's something which is, again, changed the complexion of the Supreme Court itself. I would say a third feature would be the appointment, and this really happened post 2014, where I think the Supreme Court realized and the Collegium realized that, look, we need to improve and up the quality of justice in all its various dimensions. And available to the Supreme Court was a relatively untapped area, which was members of the bar for direct appointment to the Supreme Court. And I would say that post 2014, our experience in the Supreme Court has been outstanding, that the bar appointees have been really very, very good. And they've really, lifted, I would say, the quality in terms of the administration of justice. So that's a very positive development. So if you're going to go up to 34 in terms of appointment, and we have an experience now of excellent bar members who've contributed to the Supreme Court, perhaps the time has come to ensure that there is a segment of the Supreme Court's 34 strength which is from bar members of the bar, and that need not be only from the Supreme Court bar. You could look further afield at eminent lawyers across the country and probably tap that source to really improve the quality in terms of justice which we administer. So these are some of the features which I would say in terms of evolution, which I have noticed in the last few years. We'll talk more about it, I think, as we go along in the interview.
Yes, sir. Thank you for that erudite answer. You talked about how Collegium has played such an important role post 2014 in the appointment of judges, and how bar has been such a crucial source of such excellent judges. Justice Nariman comes to my mind as a direct appointee from the bar. Going forward going forward with the topic of Collegium as the way of appointment of judges, I have a very important question regarding that. In that, I'm sorry, Har, apologies for that. Representation of communities through the judges within the judiciary has been a key point of debate in various socio-political and legal spheres. The Supreme Court Collegium was once called an old boys club, so to speak, and there have been various instances where there have been reports that the union has rejected the Collegium's recommendation owing to the proposed candidate's sexual or political orientation. How big of an issue do you perceive this to be? And moreover, do you think that there's a need for strict diversity in the bench?
Okay, so there's a number of questions. So let me just preface my answer by saying that, look, as I mentioned, I came across from Mumbai, and I'm now practicing before the Supreme Court, and I'm just looking at these judges who are drawn from all across the country. And the first thing which sort of really amazed me and continues to amaze me is what high quality judges we are able to produce across our country. I mean, I think that's wonderful for any system. That we have judges in the Supreme Court of India from all our various high courts, and because their erudition comes through their ability, their knowledge of the law, just the manner in which they conduct their courts. And so one thing which, I sort of, as a provincial sort of lawyer from Maharashtra and Mumbai, I thought that the Bombay High Court was obviously the cat's whiskers and there's nothing which can improve that. And then when you come to the Supreme Court, you say, I was quite amazed and continue to be amazed by the quality of judges which come across from, across the country. So just building on that, the two or three things that I'd say is that obviously the system is working, and the Collegium system is working well at a certain level, because we are getting very good judges up in the Supreme Court, and I would say that about the high courts as well. The second feature which I would just highlight is I completely agree with your suggestion that we need to have certain objective benchmarks, and I think diversity is amongst them. So I think there are diversities, it's a factor, is an expression which can be used for various situations. So gender is the most obvious. You mentioned sexual orientation, that could be another. It's obviously regional diversity is the third feature, etc. And so you'd get a background, the demographic in terms of caste, all sorts of other factors and backgrounds, I think, eventually weigh in the sense that they matter in terms of delivering quality justice. I'm a firm believer that if you have a diverse bench, you're likely to have a more sensitive, layered, and greater appreciation of difficult fact situations. So I would sort of plug for that, and I can quite see that yes, while the Collegium system, there have been criticisms, as you mentioned, of the Collegium system. I think by and large, if we are to replace it, we must come up with something which is better than the existing collegiums, the system that we have at present.
Thank you for that answer, sir. I think that comprises your entire point of view on the collegium. Now, moving forward with the same of the Supreme Court, in recent times, it has been dubbed as an executives court. This has mainly emerged owing to instances such as courts' refusal to stay the matter of the appointment of chief election commissioners and other election commissioners post the Anup Banwal judgment, and the unions following actions, along with an acceptance of an assurance by the Solicitor General in the re Article 370 and not adjudicating the downgrading of a state to a union territory. With such and various other instances in mind, how do you think that the Supreme Court has fared in integral constitutional matters, and is there a need for it to change its approach for the same?
Look, I'll make two or three points. First and foremost, that's a very strong expression to use in terms of it's an executives court. So let's just see what the situation over here is. The first point is, then we covered this, that there are 34 judges. That's the total sanction strength. At the moment, you may be short by a few, but so the court is sitting in different benches. So remember that. Second, I think the perception of individuals when they are on the bench varies considerably. So within the Supreme Court and within this larger set of 30 plus judges, you would have certain people whose perception is judges, whose perception is and whose preference is for a certain type of outcome. Others may have a different view in terms of how society, etc., generally should function. So I can give you, in the course of my experience, I know of several judges who are absolutely top class judges, who are extremely independent, no doubt about that, which is, an important factor in terms of being a top class judge. And nevertheless, they might have a certain worldview or perception when it comes to, and I'm just giving you one example, say tax matters, okay, where you have a contest between the citizen or the tax assessee and the state. And I have known of these judges who are really good judges, but when it comes to tax matters, they just feel they find it very difficult to decide in favor of the citizen. So invariably, they will try and see, and if there is some solution or some manner of holding in favor of the state, because that's their preferred outcome. So it's not as if that they're biased or anything, but that's their broad perception. That's the broad manner in which they look at a situation. Now, when you mention, let's look at the political scenario also. The court doesn't function in a vacuum. It's very much there in a particular political milieu. And if you have a strong executive, then there is every likelihood that the court is going to be very, very deferential to the executive's will. So I rather than go into any individual case, I would rather suggest that under our constitution, there are certain very, very basic and fundamental principles. And if the court is falling short on those basic or essential fundamental principles and looking, uh, 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 ignoring those principles to decide a particular case in favor of the executive, then perhaps that's not a correct decision individually. But I think broadly, we have to have faith in our Supreme Court. The judges, I would say, are independent. They are no different from, members of the bar. It's just that they're drawn by and large, at some point of time, they served as lawyers. They were drawn and they then serve on the bench in the High Court. A few of them, as we mentioned, are serving now directly as direct appointees. But they're essentially, you know, members of the bar with a wealth of judicial experience, primarily in the High Court and for some time in the Supreme Court, where they serve. And for all those reasons, I think it's too strong a label to use to describe our present Supreme Court, that it has become the executive's court. I don't think that might be justified.
Thank you, sir, for sharing your insights. And I believe that was a very vital example of the tax which you quoted. I think from that perspective, we can see a logical coherence between the relation of the states and the judgments which come out of it. So thank you for that vital observation. But diving more into the depth of the authoritative aspect of the judges, recently, a judge of a prominent high court resigned from the judgeship and 24 hours later joined a political party. Later, he fought for a seat in the Lok Sabha and won. Furthermore, in the past, we have seen former justices taken up positions as governors and Rajya Sabha members. We would like to ask you your take on such situations. Do you think it is right for the judges to immediately take up government positions post retirement? And what impact do you think it has on the overall image of the Supreme Court?
So yeah, so let me put it two or three. You've raised several questions. Let's just keep in mind that some of our statutes require, by qualification, as a former judge of the Supreme Court of India, or indeed Chief Justice of a High Court or a judge of the High Court. So the statute itself requires it. So this would seem to suggest that we have great faith in our judges in terms of adorning, even post their positions in the High Court and in the Supreme Court, with some sort of a statutory kind of office. So that's one. There's a whole set of statutes which kind of requires that. I would say that, and this is, I'm clearly against what you mentioned. I think it is very poor that you have it sort of shakes the foundation and the faith that the citizen has in independent judges if you have judges who jump off the bench and immediately dive into electoral politics. I think a stray instance here and there is something which the system is robust enough to countenance. It would be critiqued by people like me. It would be critiqued possibly, I'm not sure about your views, but it could be probably critiqued by each one of you as well, or some of you. At the same time, we must recognize that, when we describe ourselves as a free country, a person has a choice to enter into politics. So this takes me to another facet, and that facet which I would describe is public service. I think the problem with some of our judges, both serving and retired, is that they want to do and continue to do a whole lot by way of public service. So, public service is not just deciding in favor of the state. Under our system, public service is holding the scales of justice evenly between the citizen and the state, and deciding in favor of the citizen when he or she deserves that particular, a decision in his or her favor. But you will find that there is a rather large number of judges who, uh, who, as a matter of their perception that we are required to do public service, that they sort of end up deciding, no matter what the case is, in favor of the state. This sort of extends even post retirement into situations where you have, like some of the offices which you mentioned, that, oh no, let me continue to serve the country. So I think the vice is too much public service. I think as a judge, you must decide that case on the facts and, of course, in accordance with the law, keeping everything else aside. But if you have this notion and you're weighed down that, oh, the whole country will suffer unless I decide in favor of the state and unless I further render public service, I think that becomes a little bit of a problem. So this is a problem of too much public service, or a perception that each one of us must continue to, serve the nation, when I think judges can best serve the nation during their tenure by deciding the case on the facts and by applying the appropriate law, and not by thinking of all sorts of other extraneous circumstances as to what will happen to the country and God knows what else.
Indeed, sir. And I think we all have a better clarity over the distinction between the legal domain and what the public sector, public service in its entirety entail. So thank you for clarifying that to us. But now, exploring more on the structural aspect, in our current system, the powers of the Chief Justice of India as the master of the roster are paramount. Over the years, allegations have been made against many Chief Justices over misuse of the powers of the master of the roster. These allegations have been accentuated by occurrences like the constitution of the special bench to review an acquittal on a Saturday. With such things in mind, do you think a case is made to reduce, or perhaps at the very least, regulate the powers of the master of the roster?
So look, there are two, 3 points which you make. The first thing is, you have to trust someone, and you have to trust your Chief Justice. You have to trust your Collegium. The system is one of checks and balances. But at the end of the day, we as individual citizens, we as practitioners, students, whatever, have to trust a particular constitutional functionary. The second element which I want to highlight is that, look, there will always be some element of discretion. And I don't think you can completely abolish or remove discretion. So, for example, in say you're constituting a particular panel of two judges. I'm just giving you an example. And one of the judges says that, look, thank you very much. You're giving me the criminal roster. But, as a practitioner, I was more on the civil side or the constitutional side. So would you, Chief Justice, consider pairing me with a judge who has experience in that particular field? I mean, I've just given you one example, but there could be many others. And so the Chief Justice exercises his or her discretion and says that, yes, I'll certainly pair you, and so prepares a panel of judges which has a good familiarity and a good mix for a particular roster which is assigned to that particular bench. So that's the standard two-judge bench in the Supreme Court, or a three-member bench. Then you have larger constitutional benches, panels of 5, panels of 7, panels of 9. There again, and this has been an age-old convention, the Chief Justice has the right to constitute that particular bench. And I think that's a discretion which one should leave with the Chief Justice. It's part of your powers as master of the roster to decide as to who comes on those particular constitutional panels. The other dimension really to this master of the roster is where you have specific cases which seem to land up in particular courts. Now, I don't think the system envisages that at all. The system envisages an element of randomness before whom the bench, or who the bench is before which a particular case comes up. So there are areas of business of the court which are allocated. So, say, I'm just giving you an example, matters concerning the rent tax, or matters concerning commercial disputes. There will be 2 or 3 benches which are assigned arbitration. And it should be that the case comes up before one of these 2 or 3 benches. And within that range of 1 or 2 benches, it should be some sort of a random technological process by which a number is given and it automatically gets allocated. I think the other point which you mentioned about a Saturday sitting, etc., is, I think, probably, I don't know, because we've had quite a few Saturday sittings, and perhaps it was a misjudgment to convene a panel on a Saturday, which is not ordinarily a day of business for the court. It would strike me as extraordinary. There could be certain situations where that happens, but probably if there is, as you mentioned, there was an acquittal, surely that could not have warranted in any normal kind of measure of urgency a Saturday sitting, and it probably ought not to have been done. But that's probably an individual case, and that might, on occasion, I accept your point, that might, on occasion, leave a sense amongst the citizenry that why is a preference being given to a case such as this? Acquittals happen across the country so often, and you do not have a Saturday listing. So yes, that is the sort of action which, if it was taken, unless there was for really compelling cause, if somebody is being acquitted and he or she is boarding a flight and leaving the country on the next day or something of that sort, then there might be some sort of a situation. But if it's a routine and regular case and there is no question of the person fleeing, I cannot imagine a situation for constituting a bench with such haste.
Yes, sir. Thank you for that eloquent answer. I think that beautifully sums up on the regulation, or at least trust that people should have over the master of the roster as the allocation of matters. Now, previously you mentioned that certain judges have ideological inclination of doing too much service or too much public service by not deciding in favor of citizens where the matter requires.
So I don't think I said it was ideological. I just said that was their worldview. Okay. So I mean, the judges of the Supreme Court, people like me, we've all, people like you, we've been through college, we've been through university, we've got our law degrees, we've got a wealth of experience as we evolve in the profession. But yes, there happens to be a certain set of judges whom, one can gauge, who want to do, as I understand it, too much public service, which unfortunately means oftentimes deciding in favor of the state and against the citizen, which I don't think is really the constitutional mandate. I believe the constitutional mandate for a top class judge is to hold the scales evenly between citizen and state. That sometimes doesn't happen. I gave you an example where, outstanding judges whom I know, I mean, I would just give them the highest marks. But in certain areas, taxation, for example, they just feel no. It should be in favor. Then you similarly have cases, judges who in on the criminal roster. You have that at the trial court as well. You have that at the appellate court. These are convicting judges, and there are other judges who are more liberally inclined. So that's broadly my take. But anyway, continue with your question.
Yes, sir. I completely agree that a top class judge should always hold the scales even. But what has happened over the past decade is that Supreme Court has been subjected to scathing critiques on its approach to cases pertaining to life and liberty, as illustrated by cases like NIA versus Zahur Shah Watali and statements such as jail is the rule and bail is the exception in Gurvinder Singh versus State of Punjab. All this has led to prominent legal scholars stating that the court has undertaken an eyes wide shut approach where even if the court wants to grant bail, it cannot, only because all the avenues of liberty have been blocked by court's own judgments. In such a scenario, where do you see the bail jurisprudence in India heading?
Oh, I would think that I would be I would endorse the view that uh, bail has to be the rule. And when I say that bail has to be the rule and not jail, it's the duty of the court and each of the judges of the Supreme Court to uphold and apply this rule. And you cannot just wash your hands off, according to me, and say that, oh, the statute requires this. You can't have citizens languishing in jail. You can't have investigations which just go on and on and on. And you have situations where people are losing their lives in jail. And it's not just a question of, the liberty of that individual. When an individual is incarcerated, it has a huge mental impact. It's not just a question of 3 and 4 years lost. It has a huge mental impact on that particular person because he or she loses confidence in the system in which he or she is born and in which he or she has faith. So I think individual cases, I'm not going to mention an individual particular case here and there, but if you have a system and a systemic denial of bail, then I think people lose faith in the system. And I think I agree that there has been a constriction of liberty in this country over the last few years. And I would say that the Supreme Court of India hasn't yet realized as an institution, the enormous decline in the general level of liberty which is being enjoyed by our citizens. It's for a whole set of factors. Amongst the factors, I think there is a perception, at least that I have, of a great degree of fear. And I think the last thing which the citizens in a free country should suffer from is fear of their own government. I mean, if you do something wrong, by all means, but not if you're a comedian, not if you're a journalist, not if you're a lawyer doing human rights work. I mean, these are people who should be, who are champions of liberty. They should be supported by institutions of the state and certainly by the Supreme Court of India. And if the Supreme Court of India lets them down for whatever reason, I think it is unfortunate. And so I believe that this retreat in terms of bail jurisprudence, as I understand it, where you cannot get bail from lower courts, you have bail applications coming up all the way to the Supreme Court itself. That itself is a very poor reflection of on the administration of justice. Where imagine you have to petition all the way up to the Supreme Court for something as routine and regular as bail. So I think we definitely require a overhauling in this particular department of personal liberty, and our courts have to be much, much stronger in ensuring that personal liberty is extended to every citizen. And see, there is a difference. You have situations of violent crime, etc. And in situations of violent crime, there may be justification because there is a serious apprehension that the state has in denying bail. But if you have a comedian who is being incarcerated, some journalists, someone who expresses a point of view which you may or may not agree with, that's surely no justification. Equally, in cases where I would see where there is a strong documentary proof, or where your evidence is going to lie in those type of situations, then I don't see how you can be denying bail to citizens. Because what is the need for indefinite incarceration? So I would definitely, I firmly believe that we at the bar, first and foremost, have to be a lot more persuasive insofar as our judges in the Supreme Court and the High Courts are concerned, in persuading them, in reminding them of what the value of liberty, for one. Number two, as to how this is really impacting the citizenry. I mean, today there doesn't seem to be much of a perception that, members of the higher judiciary are going to be suffering from any immediate fear. But there is clearly a huge underlying fear among citizens who are, doing their ordinary and usual business. So I would certainly feel that we at the bar have to be considerably more persuasive as far as the Supreme Court is concerned and the High Courts, in bringing to the forefront, again, the very fundamental principles of the liberty of the individual. And apart from that individual, I should mention that I think the impact of incarceration is much greater even on his family, on his community. And so it is extremely dispiriting across the board. And it bodes very poorly for a strong and a robust democracy if you're going to have people who are unable to get bail as a regular and routine feature.
Thank you, sir, for sharing your inputs. And I'm glad that you mentioned it in this manner because, as a law student myself, we often come across articles wherein this fear, or wherein, whenever we talk about bail jurisprudence, it is often misquoted from a philanthropic or a social welfare aspect, whereas there is a clear distinction between what is philanthropy and what is currently important right now. And I believe the way you mentioned the mental aspect of how the petitions go up, it's a very alarming point which you have raised, and we're really happy that this issue has come to the
So
light.
I think it's your job and mine. It's your
Yes,
job not to forget the importance of liberty. It's my job as a member of the bar to remind the court about that. And it's my job to upskill myself. I need to upskill as a lawyer because I need to sell ideas which are so basic and fundamental to our courts for acceptance. So we can't blame the courts. I mean, we're the ones who are require upskilling. The court is people like you and me. They've been to colleges like you and me. They've read the same books. They've experienced the same contemporary history. But it's perhaps we who are at fault in not being persuasive enough.
indeed, sir. Indeed, sir. I agree. This has been a wonderful interview, and now we're finally down to the last question.
Oh, great.
Uh, So, in the modern era, the integration of technology in judicial processes is becoming increasingly important. With reference to the recent efforts by the Indian Judiciary to digitize the court records and proceedings, how do you see the master the roster system being enhanced through technological tools, considering former Chief Justice N.V. Ramana's push for a National Judicial Infrastructure Authority? How can such initiatives improve the transparency and efficiency of case allocations?
So look, I think technology has a huge. See, first is there is the technology. The great weakness, I think, in our system is that we are not adequately consumer oriented. And when I say consumer oriented, ultimately it's the litigant. Because we are here talking about dispute resolution through our court systems. So if you we, the end point has to be, or the indeed not the end point, but the starting point has to be as to how we are going to improve as a system to render from the consumer's point of view or the litigant's point of view. So here technology is splendid because it helps in terms of reducing time, increasing efficiency, productivity, and all of that. But there's a second element to it, and the second element is who is to advise on the technology, and how are we to apply and deploy it. So the first of the points I'd like to make is that I think we need professionalism in terms of management of our courts. That's a huge issue. Just now, it's judges through their registrars who manage and administer justice on the administrative side. I think there is a very strong case that just like traditionally the doctors would administer the hospitals, but now your large hospitals are all administered professionally. So we need a professional administration as far as our courts are concerned, who will deploy the best and the most suitable technology. So I think that's one big step which we need to take. I think a second step which we need to take in terms of the technology question which you raise, I think every court must provide a citizen's charter. You must be able to tell the citizen, it can't happen overnight, but you must be able to tell the citizen that, look, if you file a case on such and such a day, and it's this type of case, I assure you that your hearing will come up immediately within whatever number of days, a reasonable thing for an interim protection. I assure you that there won't be more than 2 or 3 adjournments, whatever you want to say. I assure you that your case will be your interim application will be disposed of in so much time. Your final case will be disposed of in so much time. I mean, that's the least which we would. You see, when you go into a restaurant, you have some expectation, right? You go into a hospital, you have some expectation that this is what it is going to cost, that this is how much time it's going to take, this is how my enjoyment, or that's how much the service I'm going to enjoy. I think today, uh, one of your opening questions was in terms of the court and the evolution. I think at least as far as the Supreme Court is concerned, the way I look at it, while we have deployed technologies, and I think that's a good thing, I think there is still too much of a waste of time and resources, not just of the court, because the court is working, like crazy. Our judges are so hardworking. They are very productive. But in terms of, I mean, importantly, if we are you can't have a case of a citizen which comes on Tuesday after Tuesday after Tuesday after Tuesday, 6 and 7 and 8 times. It means there's something wrong with our system itself. It probably should be such or organized in a manner by which it comes up on a particular day and is disposed of. At the most, it'll spill over to another day. I think that's reasonable. I think that's fair. So I think there's a lot of room for technology for those kind of things. On your question regarding master of the roster and technology, yes, you have many systems by which you have a random allocation of cases. But at the same time, there will be certain types of discretion which have to be exercised. I think so long as the discretion is exercised, in a fair manner and in a reasonably transparent manner, and doesn't cause these kind of eyebrows to be raised that how did this happen? How did this case land up before X or Y? Or why did it land up on a Saturday? Then those are causes of concern. That erodes trust. I think so long as the master of roster exercises discretion in a manner by which it enhances trust and by which it builds trust in the citizenry, I don't think it should really have a problem. There shouldn't be really much of an issue.
Thank you, sir, for this session. We really liked your views that you shared.